Good morning, friends. Today's topic is establishment of appellate tribunal under RERA. Establishment of appellate tribunal. It is for the speedy remedy. Government established RERA tribunal. It is exclusive for real estate disputes. So, after constitution of tribunal, all the cases should be transferred to the tribunal. This tribunal came into existence with effect from 30th 4 2017. Government may establish one or more benches of the appellate tribunal by various jurisdictions in a state or union territory. For example, one state can create one bench, or two or more state, two or more benches in a state or union territory, or single tribunal in one state, or two or more state can go for one single tribunal, or two or more union territories go for one single tribunal. Every bench of the tribunal shall consist of at least one judicial member and one administrative member plus one chairman. Who can prefer an appeal before the appellate tribunal? Any person aggrieved by the order, decision, direction made by the RERA authority or by an adjudicating officer, he may prefer an appeal before the tribunal having jurisdiction over the matter. In the case of promoter, he has to deposit 30% of the penalty before the appellate tribunal when he wants to file an appeal. Every appeal should be preferred within a period of 60 days from the date on which the copy of the order made by the authority is received by the government or aggrieved person, and it shall be accompanied by prescribed fees. Tribunal may entertain any appeal after expiry of 60 days if it is satisfied that there was sufficient cause for not filing appeal within that period. The tribunal shall dispose the appeal within a period of 60 days from the date of receipt of the appeal. If the tribunal could not dispose the appeal filed within the period of 60 days, it shall record its reasons in writing for not disposing of the appeal within the period. The tribunal, for the purpose of examining the correctness of any order, shall call for the records relevant to disposing of such appeal as it thinks fit. Now, composition of tribunal: one chairperson and two members, one judicial member and one administrative member. The chairperson and members of the authority are appointed by the appropriate government on the recommendation of the selection committee. What is the selection committee? Selection committee consisting of the Chief Justice of High Court or his nominee, and secretary dealing with the housing, and secretary dealing with the law department. In the case of judicial member, he should have held the office, judicial office in India for at least 15 years, or he has been a member of the Indian Legal Service and held the post of additional secretary, or he has been an advocate for at least 20 years experience in the field of real estate matters. In the case of technical or administrative member, the person should be well versed in the field of urban development, housing, real estate development, infrastructure, economics, planning, law, commerce, accountancy, industry, management, social service, public affairs and administration, and experience of at least 20 years. Or he has held the post of additional secretary in the central government or equivalent post of the government. How the appointments are made? Chairperson is appointed by the government in consultation with the Chief Justice of High Court and recommendation of the selection committee. Selection committee consists of Secretary of the Department of Housing and Law. Selection committee recommend and forward the name to the government. The person should not have any financial or other interest. Tenure of the person. They shall hold the office of a term not exceeding 5 years from the date on which he enter into the office or until they attain the age of 65 years, whichever is earlier. They are not eligible for reappointment. The person should not have any such financial or other interest as it likely affect prejudicially his function as a member. The person can relinquish his office by giving in writing notice to the government not less than 3 months. Any vacancy caused to the office of the chairperson or any member shall be filled up within 3 months. Tenure of the chairperson not exceeding 5 years from the date of entering the office. He is not eligible for re-election. He can hold office up to 67 years. Members can hold office till 65 years. Removal of chairperson and other members. Government may remove the chairperson or members from the office on the following grounds. If he has been adjudged as insolvent, if he has been convicted of an offence involving moral turpitude, if he has become physically, mentally incapable of acting as member, if he has acquired such financial interest and it likely to affect prejudicially his functions, if he has abused the position so as to render his continuance in office is against the public interest. The chairperson and member shall not be removed from the office without enquiry made by the judge of the High Court. He has to be informed of the charges against him. He should be given a reasonable opportunity of public hearing. The restrictions on chairmen or member on employment of office. There are some restrictions after retirement. They cannot take employment as they like. The chairperson or member shall not accept any employment connected with the management or administration of the organization which has been associated with any work under the Act with reasons to hold office. He can take appointment of employment under appropriate government, local authority, statutory authority, corporation established under the state or central government, but he cannot take an appointment with the management and the administration of builders. He cannot act on behalf of any person or organization in connection with the specific proceedings. He cannot act on behalf of any person. He cannot advocate. He shall not give advice to any person using information which is obtained in his capacity as his chairperson, which informs is available to him in the public. He cannot enter into contract or accept any appointment to a board of directors. He shall not communicate or reveal information on any matter which has been brought under his knowledge while acting in the authority. Power of the tribunal. Tribunal shall not be bound by the procedure laid down by the code of procedures. It is not bound by the rules of the evidence. It shall have power to regulate its own procedures. The tribunal, for the purpose of discharging its functions, has the same powers vested in a civil court under the Civil Procedure Code in respect of the following matters. For example, summoning and enforcing the attendance of any person and examining in oath. Discovery or production of document. Receiving evidence on officer. Issuing commissions for the examination of witness and document. Reviewing its own decision. Dismissing application for defaulter. In all the cases, it can exercise the power of the civil court. Appeals. Now, you know that agreed with the order of the RERA authority, any party can prefer an appeal. If aggrieved party is promoter, he has to deposit 30% of the amount plus 30% penalty. In addition to that, it will call upon the promoter to deposit amount which is compensation money. If aggrieved party is allottee, he shall deposit such amount depending upon the cost of the appointment. Even government can prefer an appeal within 60 days. Appeal order is final. Authority to pass interim order and send order for disposal. Reasons for the non-disposal should be given within 60 days. It can call for records and reports. It is not bound by the provisions of the Civil Procedure Code. It can review its conditions, it can pass order ex parte. Once order is passed, it will be transferred to civil court for execution. Now appeals before High Court. Agreed with the order of the appellate tribunal. Within 60 days the communication of the order, appeal can be filed before the tribunal, filed before the High Court. Order passed by the appellate tribunal is executable as decree. Every order made by the tribunal shall be executable as a decree of civil court. Tribunal shall have all the powers of civil court. Tribunal may transfer any order made by it to the civil court. Civil court shall execute the order.